Good morning, friends, and welcome back to the lecture series with me, Sanjana Mittal. Today's topic of discussion would be the process of obtaining patent in India. Now, patent, as we know, is a bundle of rights which is basically it's a bundle of exclusive rights given by a government authority to an inventor for a certain period of time in the invention that he has created. So during that period, he is the exclusive user of the invention, and along with exclusive use, he gets certain other benefits and rights in his own invention. Now, after we are done with the whole process of invention, you will realize that this process of invention of obtaining patent in India for an invention is a very thorough and a very meticulous process requiring a constant supervision and constant involvement of the owner of the invention. Now, without further much ado, I will begin with the process of invention. When we talk about the process of obtaining patent in India, there are two parts of the process. The first being the informal part, the other being the formal part. When we talk about informal part is nothing but the basic research that an inventor is expected to do at his level to make sure that the invention for which he is applying the patent is actually patentable. It falls within the four borders of patentability, and also it does not fall under the ambit of the exclusive inventions which have been told to be non-patentable under the Indian Patents Act. So that being done at the non-formal level, at the individual level by the inventor, and once he is satisfied that yes, his invention is quite patentable, he moves on to the formal process. The formal process begins with filing of an application with the patent controller. Okay, controller of the patents. The inventor has to go and file a formal application with the patent of the controller of the patents. Not only does he have to file an application, he is required to file another very important document, which is known as specification. Now, patent is considered as a techno-legal document. Okay, it's known as a techno-legal document. So when you talk about a techno-legal document, the legal aspect of that document is covered by the application, which consists of details such as name of the inventor, place of business, address, etc. And the techno part or the technological part is covered by the specification, which lays down the stepwise and elaborate process of the invention. Specification is the most important document when you're talking about the process of patenting. Why? Because it is the document which consists of the detailed description of the invention. It talks about the working of the invention. It talks about the claims that the inventor seeks to maintain. That is, how he wants to describe that his invention is better, is an addition to the state of art already existing about that invention in his field. So the whole idea of specification is to give a very detailed description of the invention that he has created. So what am I saying? The beginning of the process of patenting in India begins, the level one begins with filing of two documents, the application and the specification, okay, with the patent office or the controller of the patents. So after this being done, what one thing very important we need to know over here is about specification. Specification is of two types. Specification is either provisional or specification is complete. Provisional and complete, as the term suggests, provisional means something which is in between, which is intermediary. Complete is which is full and final. It may so happen that inventor may not have completed his patent, but is only in the last leg or towards the completion of the invention. And he knows that after he has completed his invention, he will for sure go and file for a patent. However, in order to make sure that he gets priority over the invention, in respect to any other person who is working in this regard or who is working on a similar invention, that is, he needs to block the priority over that invention. The person may go and file the application with a provisional specification. In provisional specification, the inventor is not expected or not required to give a detailed stepwise description of an invention, but to give an overall working, inform about an overall working of the invention. However, once he has filed the provisional specification, the inventor is required mandatorily by law to file complete specification within 1 year of filing the provisional specification. If he fails to do so, his application will be considered to be abandoned. Again, I'm going to explain this to you again in simpler terms, now that you have some basic idea. प्रोसेस स्टार्ट किससे होता है? फाइलिंग ऑफ एप्लीकेशन से होता है. बट पेटेंट के केस में केवल एप्लीकेशन फाइल नहीं की जाती है, एप्लीकेशन के साथ में एक डॉक्यूमेंट जिसको हम स्पेसिफिकेशन कहते हैं वो भी फाइल किया जाता है. जहां पे लीगल एस्पेक्ट पेटेंट का एप्लीकेशन कवर करती है, टेक्नोलॉजिकल एस्पेक्ट पेटेंट का स्पेसिफिकेशन कवर करता है. स्पेसिफिकेशन दो तरीके के होते हैं, या तो प्रोविजनल स्पेसिफिकेशन होता है या कंप्लीट स्पेसिफिकेशन होता है. अगर आप अपना इन्वेंशन कंप्लीट होने के पहले, उसकी वर्किंग वगैरह चेक करने के पहले आप अपना पेटेंट के लिए एप्लीकेशन फाइल कर रहे हैं, तो आप कंप्लीट स्पेसिफिकेशन ना फाइल करके प्रोविजनल स्पेसिफिकेशन फाइल करते हैं, जिसमें आपको डिटेल्ड स्टेप वाइज डिस्क्रिप्शन नहीं देना होता है, बट एक ओवरऑल वर्किंग के बारे में, एक ओवरऑल डिस्क्रिप्शन के बारे में इंफॉर्मेशन देनी होती है. हाउएवर, अगर आपने प्रोविजनल स्पेसिफिकेशन फाइल किया है अपनी एप्लीकेशन के साथ में, तो 1 साल बाद आपको कंप्लीट स्पेसिफिकेशन मैंडेटरीली फाइल करना होता है. अदरवाइज आपकी एप्लीकेशन, इन्वेंटर की एप्लीकेशन अबंडेंट मानी जाती है, उसको कंसिडरेशन में नहीं लिया जाता है. Now the question arises, why would an inventor go and file for a provisional specification? Let's understand this with an example. Say A and B both are working on the same invention. A knows that he will be able to wrap up his invention within coming 6 to 7 months, and after that he will go and file the patent. But he fears that if B is able to complete his invention before him, he may go and file for the patent, in which case A will not be considered as a true inventor and first inventor of the invention, which is the major requirement of obtaining a patent. You have to be a true and first inventor of the invention in order to be able to obtain the patent on that invention. So what does he do? He goes today and he goes and files the patent application and a provisional specification with the patent office. In this case now, if B will go tomorrow and if B will file complete specification, even in that case, it will be A who will be considered as the true and first inventor, provided he is able to file the complete specification within 1 year of filing the provisional specification. So when you talk about the beginning of the process or level 1 of the patent process application, you understand that the beginning of the process begins with filing of the application, and it begins with filing of the specification. Once these two things have been filed, once application has been filed, once complete specification has been filed, we move on to level 2 of the patent obtaining process. However, if you have filed application and with application, you have only filed a provisional specification, what do you get? You do not get to go into level 2, but you only get a window of 1 year, during which window you have to file the complete specification. If you file the complete specification within that 1 year, it's okay. You will go on to second leg of the process. But if you fail to file the process, then your application is considered to be abandoned. So this is the first level of obtaining the process of patent in India. I hope I have been able to make myself clear. In the next lecture, in part 2 of obtaining process of patent, we will go on to the second level, therefore and thereafter. Thank you so much for patiently listening to my lecture.